Hello students, let us continue from where we left off during the last lecture. In the last lecture we had discussed about FERA and how later on in 1999 FEMA came into existence, and we are trying to understand in more clarity what FEMA Act consisted of or constituted of, and there are some more aspects for us to understand. So, during this lecture we will try to continue and understand the remaining aspects of FEMA. The objectives of today's lecture are to continue and understand the features of FEMA, to analyze the difference between FERA and FEMA. The next aspect is contravention and penalties. So, this aspect also a very important aspect. The issue of contravention and penalties is covered in section 13, and it says that if any person contravenes any provision of this act, he shall upon adjudication be liable to penalty up to thrice the sum involved in such contraventions where such amount is quantifiable, or up to 2 lakh rupees where the amount is not quantifiable and where such contravention is a continuing one, further penalty which may extend to 5,000 rupees for every day after the first day during which the contravention continues. Now, as we know, FEMA gives only lots of importance where foreign exchange matters or foreign exchange changes hands. All the other aspects are not given so much of importance under FEMA. FERA was quite broad and it covered various other aspects, but under FEMA it is only the exchange or the transactions that take place that came under FEMA. Section 14 says that if a person concerned fails to make full payment of the penalty imposed on him within a period of 90 days, he shall be liable to civil imprisonment. Only in the case of these transactions that take place, if someone defaulted, they did not follow the rules, then they would be penalized. And there were provisions which tried to cover defaulters also. In the case of defaulting or in the case of continuing to do the wrong things, then also they had to, the fine would increase and ultimately also civil imprisonment was there. Chapter 5 deals with the issue of adjudication and appeal. Section 16 states that the central government may appoint adjudicating authorities by holding an inquiry in the manner prescribed after giving the accused person a reasonable opportunity of being heard for the purpose of imposing any penalty. So, section 17 provides for the appointment of one or more special directors appeals to hear appeals against the orders of the adjudicating authority. So, there is a provision where people can appeal against the adjudication. So, section 18 says that the central government shall by notification establish an appellate tribunal to be known as the appellate tribunal for foreign exchange to hear appeals against the orders of adjudicating authorities and the special director appeals under this act. The Directorate of Enforcement, Chapter 6 deals with the establishment of Directorate of Enforcement and its powers, etc. Subsection 1 of section 36 states that the central government shall establish a Directorate of Enforcement with a director and such other officers or class of officers as it thinks fit, who shall be called officers of enforcement for the purpose of this act. Subsection 3 of section 37 states that the Director of Enforcement and other officers of enforcement shall exercise the like powers which are conferred on income tax authorities under the Income Tax Act 1961 and shall exercise such powers subject to such limits laid down by the Act. Now, let us also try to see some miscellaneous aspects which come under FEMA, which will explain us the characteristics of FEMA. The last chapter, chapter 7, consisting of section 39 to 49, deals with miscellaneous issues. Subsection 1 of section 40 empowers central government in the public interest and by notification to suspend or relax the provision of the Act in certain circumstances. So, there are provisions where the Act can be overruled also, and section 41 empowers the central government to give general or special directions to the Reserve Bank. Section 42 provides that where contravention of any of the provisions of this Act is committed by a company, the person responsible for the conduct of its business shall be deemed to be guilty of the contravention. Section 44 bars the prosecution of legal proceedings against the officer of the central government or the Reserve Bank of India or any other person exercising any power or discharging any function or performing any duty under the provision of the Act for anything done in good faith. So, here the government officers, the regulating officers are protected against any legal action because they were supposed to do things in good faith, and if they are not protected, then they may not take action when required for fear of being targeted, and therefore, the government officers and regulators were made strong and not allowed to be dragged into the court. Section 45 empowers the central government to remove the difficulties in giving effect to the provisions of the Act. Section 46 empowers the central government to frame the rules, and the section 47 empowers the RBI to make regulations to carry out the provision of this Act and the rules made thereunder. So, the RBI officers also are protected, and they were also made in charge of formulating the rules and regulations, so this Act can be followed. Section 48 provides for laying before Parliament the rules and the regulations made under the Act. So, Section 49 provides for repeal of the Foreign Exchange Regulation Act 1973 and the dissolution of the appellate body constituted under Section 52 of the said Act. So, there was an appellate body which had to enforce these rules. That body also was removed in order to make FEMA stronger so that it could take over from FERA. So, these are some of the features of FEMA. The role of Reserve Bank has been restricted under this Act. Only in few cases does RBI figure, and the shift was from regulating to managing of foreign exchange. Some subject experts say that the shift from FERA to FEMA was very wide, as is clear from the name of the Act itself. The emphasis under FEMA is on exchange management, whereas under FERA the emphasis was on exchange regulation and exchange control. Under FERA, it was necessary to obtain RBI's permission, either special or general, in respect of most of the regulations thereunder. FEMA has brought about a sea change in this regard, and except for Section 3, which relates to dealing in foreign exchange, etc., no other provision of FEMA stipulate obtaining RBI's permission. The demand for new legislation was basically on the following counts. Number 1, FERA was introduced in 1974 when India's foreign exchange reserve position was not satisfactory. Accordingly, stringent controls were required on the use of foreign exchange. With improvement in the foreign exchange position, it is argued that such stringent controls are not now required. Secondly, India had given notice to IMF in August 1994 that it had attained Article 8 status, and this notice meant that no restrictions will be imposed on remittances of foreign exchange on account of current account transactions. So, the argument against having FERA in place, the first argument is that when FERA was instituted in 1973, the foreign exchange situation was very precarious, but since then the foreign exchange position has become more comfortable, and so a strong act, regulatory act like FERA is not needed. That was the argument that was placed earlier. The third is that the private corporate sector had been complaining for long against what it termed a draconian provision of FERA, which gave unbridled power to the Enforcement Directorate to arrest any person, search any premises, seize documents, and start proceedings against any person for contravention of FERA or for preparations of contravention of FERA. And the contravention under FERA was treated as a criminal offence, and the burden of the proof was on the guilty. Many Indian investors also felt that this law was very harsh, draconian, and that's because It gave unlimited powers to the regulatory authority in that they could search the houses, seize the documents and arrest the people who have committed an offence or who have not followed the rules and regulations of FERA. In fact, not following FERA rules was a criminal act, and so they were against this type of a act, and this is why they advocated that FERA should be scrapped, and that is how FEMA came into existence. FEMA has changed all this. As stated earlier, the purpose of FEMA is to facilitate external trade and payments and to promote the orderly development and maintenance of foreign exchange market in India. As far as the promotion of orderly development and the maintenance of foreign exchange market is concerned, FEMA is silent. However, as far as facilitating external trade is concerned, Section 5 removes restrictions on withdrawals of foreign exchange for the purpose of current account transactions. As external trade, that is import and export of goods and services, involves transactions on current account, there will be no need for seeking the permission of Reserve Bank of India in connection with remittances involving external trade. However, Section 5 confers powers on the central government to impose reasonable restrictions on current account transactions in consultation with the Reserve Bank of India. But this seems to be just an enabling provision added keeping in view the experiences of some East Asian countries during the year 1997-98 crisis, which required stricter exchange control. As far as the draconian provisions are concerned, FEMA has reduced their rigor significantly. The contravention will now be treated as a civil offence. Thus, FEMA removes the threat of imprisonment which businessmen abhor. So, this is a very important change, because sometimes fear is required in order to implement a law strongly. When there is no deterrent, then laws may be flouted. But FERA removed the clause that not adhering to the rules of FEMA is a crime. So, they have removed this law and facilitated those who default in a manner that it is called a civil offence rather than a criminal offence. Now, they will either compound their illegal acts by paying a fine if it is not too high, otherwise they will pay lawyers to engage in lengthy and mostly inconclusive litigation with the government. So, the big question is whether India will be able to maintain its sovereign rights. Every country has a right to regulate the activities in such a manner that they are for the benefit of the country. But with FERA, an act which is quite soft, which will not be able to regulate the happenings, with this type of an act, will India be able to maintain its sovereignty is a big question, and therefore the government and the authorities will have to think as to what are the regulatory measures that have to be put into place so that the interests of the country are maintained. Now, let us summarize what we have learned today. We are trying to understand what are some of the concessions that were granted to FERA companies, and we came to a conclusion that FERA was made redundant. There was no use of such an act. It was as good as non-existent. And then there were arguments that were put forth for the scrapping of FERA. FEMA came in 1999, and since then lots of the regulatory aspects have been dropped. Regulation of and control of foreign exchange has been neglected, has been given the back seat, and only facilitation of trade and payments has been covered over FEMA, and people who do not follow the act do not come under criminal offense. They are people who offend. The people who do not follow the FEMA act are taken as only civil offenders, and this brings to us the question whether India will be able to manage its sovereign rights with such a soft law. Now, take down some questions for self-assessment. Number 1, what were the arguments put forward to justify the scrapping of FEMA? The second question is, what are the differences that exist between the provisions of FERA Act and FEMA Act? You can refer to the latest editions of number 1, Indian Economy by Rudradath and Sundaram, published by S. Chand and Company. Number 2, Indian Economy by Mishra and Puri, published by Himalayan Publishers.